My name is Brent Vassar, President of the McCracken County Bar Association, and I would like to welcome you to the People's Law School. The People's Law School is a program of instruction presented by local lawyers who have volunteered their time. The participating lawyers have many years of experience in the areas of law about which they will be speaking. However, the viewer is cautioned that no advice is intended to be given during the discussions. We recommend that each of you consult a lawyer on a face-to-face basis concerning the merits of your particular case. With that in mind, we hope you enjoy the presentations.
Welcome to the People's Law School segment on personal injury law. I'm Craig Housman. I graduated from Vanderbilt Law School in 1973, and ever since the spring of 1973, I've been here in Paducah practicing personal injury, workers' compensation, and Social Security law on behalf of injured workers or persons. With me today are two other experienced Paducah attorneys. Mr. Lanny King is a partner in the law firm of Stout, Farmer, and King. Lanny graduated in 1997 from the University of Kentucky School of Law. He has a master's in public administration in addition to being an attorney. He clerked for 2 years with U.S. District Judge Tom Russell, and since that time he has been actively engaged in the private practice of law with an area of concentration in general civil litigation practice. His firm also handles a good deal of bankruptcy work. Also with me today is Dan Stratemeyer. Dan received his law degree from the University of Illinois in 1992. He practices presently with Saladino, Oaks, and Schaff. Before that, he spent 11 years with the law firm of Bale, Stouffer, and Graves. The topic we are going to deal with today is personal injury. Dan, what category of case do you see most often, do you get the most inquiries about under the heading of personal injury law?
Without a doubt, and I'm sure this applies to probably most personal injury attorneys, is car accidents, truck accidents, by far the most calls in those areas.
Okay. Now, it's just so we have some understanding with our listeners, the work that you did for 11 years with Bale Stouffer was primarily on behalf of the defense, and the work that you do now is primarily on behalf of the injured workers, and I think, or injured parties. And Lanny, you have a general practice where you represent some on both sides.
Yes.
Are there some words of advice that you would give if you could talk to someone immediately after an accident has occurred?
Yes. Oftentimes someone comes into my office about litigation on a car wreck up to 2 years after the accident. Over that time, memories fade and the documentation of what actually happened aren't as good as they are at the accident scene. I've found, and I bet everybody here has found, that the police reports, if it is to the police officer a minor accident and there's no death involved, are not as thorough as they should be. What you think is very clear that happened at the accident scene 2 years later when people are trying to remember what happened aren't so clear. Also, people tend to get the police report and believe that if the police report agrees with their side of the story, then that's the end of the story. But the reality is that the police report doesn't count for much other than to refresh the police officer's memory on who told him what at the accident scene. So I would recommend in any accident, no matter how small, even if you don't think somebody is hurt at the scene, to make a list of all witnesses and get the phone numbers of anybody who may have seen the accident and get them to tell you what they saw, because you should plan on there being a lawsuit several years later, even if at the time that's the last thing on your mind.
Dan, if you were in the same situation, is there anything else you would add to
Well, this may be a little self-serving on my part, but I think there's nothing wrong with calling an attorney, whether you think you're at fault or whether you're the victim or the party not at fault. It doesn't hurt to get advice or to talk to someone about the accident. There are many quirks to the laws in motor vehicle accidents, of who pays the medical bills versus who pays the property damage, of who should be contacted, your insurance versus their insurance. Again, who's paying the medical bills? Should it be your car insurance? Should it be your health insurance or Medicare or Medicaid? There's a lot of questions involved in an auto accident that really you need to speak with an attorney no matter what. Even if it's a small fender bender, there's property damage issues. Even if there's no injuries whatsoever, I think you need to talk to an attorney.
At the very least, you need to put your insurance company on notice that there has been an accident. There is, if years go by and you never contact your insurance company, they can eventually deny a claim because they weren't given proper notice. So the sooner you put them on notice. But I would agree with Dan that if before you give a recorded statement or anything of that nature to anyone, you should probably consult an attorney.
Okay. One of the things that you said earlier, Lanny, was about some of the rules. If the police officer writes up the report saying driver of vehicle number 1 was not paying attention, and the report appears to place all the fault on driver number 1, doesn't that decide it?
The only thing the police officer can ultimately testify to is what he saw with his own eyes or heard with his own ears. So he can later testify what somebody told him if that person is available to also give their side of the story. But his conclusions, if he did not see the accident himself, are probably not admissible.
Not even admissible in evidence.
Not admissible in evidence.
And Dan, you talked about trying to figure out whose fault it was. One of the things that Kentucky does, which is different from when I started practicing and is different from the way it works in some other states, is we have the law called pure comparative fault. Would you explain what that means as a practical matter?
Well, basically, pure comparative fault means that in an auto accident, this could apply really to any accident, but we're talking about auto accidents right now, that sometimes the cause of the accident is not so clear cut to someone looking at it. It might be to the persons involved, it's either their fault or the other person's fault, but many accidents result in a situation where both parties are slightly at fault. And in a situation where both parties have some fault, in other words, it's comparable fault or comparative fault is the word you use, that means that a person's damages, whether it be property damages or injuries, personal injuries that they receive, that their damages actually get reduced by the amount of comparative fault that resulted from the accident, meaning they are reduced by the own percentage of their own fault for the accident. So if a person is 50% at fault for the accident, that's probably the easiest one to use, they'll only get 50% of their damages recovered, and that's pure comparative fault.
Lanny, who winds up deciding this? Because it seems like it'd be pretty fuzzy and gray.
It is pretty fuzzy and gray, and ultimately a jury is the one to decide this. And I think during the course of our discussion today, we may talk about juries and trials. The vast majority of personal injury claims, even if litigation is filed, are settled prior to going to a jury. But the way we have to evaluate the claim as lawyers is what would happen if we were to go to a jury, and that's why we're going to talk about juries today. And as Dan was talking about the comparative fault, there is no exact answer, and very few lawyers will, when you tell them what happened, will tell you, well, the other person's 50% fault and you're at 50% fault, and this is the amount of money you're going to be able to recover from this claim. It is an open question. A jury will be allowed to hear the testimony of all the parties and look at the physical evidence and decide who's completely at fault or whether they should divide the fault among the parties. And so it is a very large gray area.
And so does it boil down to, in trying to reach a settlement without having to go to trial and have a jury decide it, is it just a matter of both sides coming to some sort of educated guess about what a jury would do with the facts?
Educated guess, experience of the parties making the decision of how many times have you seen a similar accident, of how was it decided in the past by a jury if that case did go to a jury. A lot of common sense just works into it. A lot of people say, well, if they're rear-ended, it's automatically the other person's fault. That may be true a lot of times, but sometimes that's not true. A lot of times it's really just, like you say, educated guesses, common knowledge, experiences over your career. But ultimately, if you want someone to make the decision for you, you're always welcome to walk into the courthouse and let a jury decide.
Okay. Lanny, carrying our accident scene victim one step further beyond the scene of the accident, if that person goes to the emergency room, what insurance is applicable if there is a motor vehicle collision that's caused the patient or the person to have to go to the emergency room?
Under Kentucky law, there is insurance that should be on every policy called no-fault insurance. You may hear us today refer to it as PIP or BRB, but commonly known as no-fault insurance. Every policy in Kentucky is supposed to have $10,000 of no-fault, although you're allowed to purchase up to $100,000 of no-fault insurance. Though I rarely see those on the policies. But the first $10,000 in medical expenses and lost wages are paid by no fault. That's assuming that you have insurance and there's not some workers' compensation involved or other issues like that.
Dan, is there a good reason to utilize the no-fault insurance for paying the medical bills attributable to a motor vehicle accident as opposed to turning it in on the injured person's health insurance if they're lucky enough to have Anthem or Blue Cross Blue Shield or Cigna or somebody?
Sure, there's a very good reason. One, it's the law. When it comes to no-fault law, you are supposed to turn your medical bills in to your auto insurance without getting into a lot of detail about the $10,000 of abolishment of tort rights, which is maybe a discussion for another day. That is what you're supposed to do. Lanny mentioned work comp. When an auto accident happens, when you're on the job, there's a little bit difference there on how that works. Mm-hmm. But right now, if we're talking about auto accidents happen and the person who's injured is not on the clock or working at the time, it should be turned into their no-fault law. And in answer to your question is, if you turn it into your health insurance or Medicare or Medicaid, each one of those entities have what are called reimbursement or subrogation rights. That means if you would ever potentially get a settlement or a recovery in court at trial, anything that those entities have paid, you might possibly have to reimburse those entities for any bills that you've paid. Whereas with no-fault law, it's not quite, or the no-fault benefits, it's not quite like that. So yes, one, it's the law, and two, if you let someone else pay, you might be paying them back in the long run anyway.
Even if there's not enough money to go around.
That's exactly right. That's exactly right.
And Lanny, what happens if the trial is 2.5 or 3 years after the accident and no one has ever asked that the no-fault insurance pay the medical bills?
There's a 2-year statute of limitations on paying no fault, and if they've never paid, after 2 years, roughly after 2 years, no fault no longer has to pay, is no longer obligated to pay. But at trial, you lose the first $10,000 of your claim against the other party, regardless of whether the no fault was paid. Adding to what Dan said, I think if you have health insurance and you are missing work because of the accident, I would recommend you talk to a lawyer about the best way to handle the no fault benefits. You can direct the no fault payments to be paid toward your lost wages, as opposed to the medical bills, if you have enough lost wages to offset that. Also, if it is a serious accident and you are transported to another hospital and your bills are mounting very quickly, it may be best to consult a lawyer to discuss which of the medical providers you want paid from no fault, as you start considering the other health insurance issues and where other recovery may come. So that is the first, the quickest insurance decision that has to be made, and a reason that you may want to consult somebody. Again, primarily if you have lost wages as well as medical expenses, or if you're having medical expenses for more than one provider and they're starting to mount quickly.
Okay. I've forgotten which of us said it a while ago, but something to the effect that all motor vehicle collisions, if there's insurance, there's $10,000 worth of no fault at a minimum. That raises one pretty important exception. What happens if somebody's on a motorcycle and gets hurt in a motor vehicle accident?
Well, again, auto accidents that we've been talking about, of course, I've been talking in terms of cars and trucks. Motorcycles are treated differently in this state. And unlike an auto policy, a car or truck policy, where the $10,000 of no-fault coverage is mandatory, in other words, it's in every policy that's written, when it comes to motorcycles, it is an optional coverage. And so whenever you go in and purchase your insurance for a motorcycle, I'm sure a lot of people just assume, well, I have this no-fault coverage on my cars, I must have it on my motorcycle. That could be a costly mistake, because you don't want to learn after an accident that when you're on a motorcycle that you do not have this no-fault coverage. And because it is an optional coverage, a lot of people find out candidly, sometimes the hard way, that they don't have no-fault insurance when they're driving a motorcycle. So yes, if you have motorcycles and cars, they are, for no-fault purposes, different types of vehicles, different types of insurance, and you really have to talk to your insurance agent in great detail about what types of coverages you can get for your motorcycle that are different than your autos and trucks.
And Craig, if I could add to that, another problem with motorcycles is, even if you do not have no-fault coverage for your motorcycle, you are still prohibited from recovering the first $10,000 in your claim against the other party or against any other insurance. So even if you haven't purchased that additional coverage, it seems to me that the Kentucky legislature has something against motorcycle riders to put them in this position, because most people don't realize that not only do you not have the coverage, but you lose your claim against someone else for the first $10,000. So if you drive a motorcycle, I would highly recommend you having another talk with your insurance agent.
And if, for instance, to carry that one step further and getting back to one of Dan's points, if you didn't have no-fault insurance and you got hurt on the motorcycle and you've turned your bills in to Anthem or Blue Cross Blue Shield or some other health insurance carrier, do they then have a right to collect out of what you were awarded for pain and suffering or lost wages or whatever, every dime that they've paid, even though you're not going to get $10,000 worth of medical bills?
Yes, it can, because the health insurance policy, most of them these days, I hate to say all, but most of them these days have reimbursement clauses that require 100% reimbursement regardless of what the actual award represents. So even though you may technically not be able to recover that $10,000 of medical bills from the person who caused the accident, you may still have to repay it from the remainder of your settlement back to the health insurance company.
From the standpoint of lawyers talking with folks after they've been involved in an accident, are there some tips that we might give the individual who thinks he's doing just fine if he goes down to his local insurance agent and says, just give me full coverage?
Go ahead, Lanny.
Well, I hear the term full coverage a lot, and I still haven't figured out exactly what it means. I believe that in the insurance parlance, full coverage means that you have collision insurance, which will pay for property damage to your car, as well as the other required coverages, such as the $10,000 in no fault, $25,000 minimal limits in liability coverage, meaning if someone else is to sues you for damage that you've caused to them, the most your insurance company will pay is $25,000. And then the law also requires there to be, or give you the option to have uninsured motorist coverage of $25,000, requires you to have $25,000 of uninsured coverage, meaning if the person who hits you and is at fault for an accident, you can recover up to $25,000 from your own insurance company. And then there is the option of $25,000 in underinsured motorist coverage, which may also be in, when they talk about full coverage, they're also throwing in the underinsured motorist, meaning if the other person only has $25,000 in coverage, liability coverage, and you have $50,000 in damages, you can recover the additional $25,000 from your own insurance company. That, I believe, may be what the insurance company is, or the broker may be referring to as full coverage. But I would recommend in this day and age that the minimal limits required by Kentucky law simply is not sufficient. You can purchase additional liability coverage so that to protect your own assets should somebody sue you of unlimited amount. And you can also purchase additional PIP or no fault that we talked about earlier, which I would recommend. And I also recommend having additional uninsured and underinsured motorist coverage, because odds are if you are injured in an accident, the person who is at fault for that accident does not have sufficient insurance coverage. That's what I see more often than anything. But personally, I would also recommend having as much, if you have any assets, if you're not in a position where you have no assets and no equity in your home, or no money in the bank account and no job, other than that circumstance, I would recommend you having as much liability insurance as you can afford. Because it doesn't take much in this day and age for medical expenses to get really high. And if you make a mistake and get in an accident, it can get in excess of your liability insurance coverage pretty quick.
Okay. It sounds like with the various interplay between workers' compensation and health insurance and car insurance that things can get pretty complicated. It's no longer just an issue of who caused the accident and how badly was the person hurt. Is that what each of you have found to be the case?
Well, as I alluded to earlier, take that same auto accident, but this time, instead of going home from work, you're actually on the job at the time. Mm-hmm. Well, if you're injured in a situation like that, you actually have two potential claims. You have what is normally referred to as a workers' compensation claim, a work comp claim. That is because you were injured on the job. You may potentially also have a second claim, what is called a third-party claim or personal injury claim, against the person who caused the accident. And there is a lot of interplay between those two claims. Probably the first one, again, which we mentioned earlier, in that situation, it is the work comp insurance company that is responsible initially for the medical bills and not the no-fault insurance. Although you can use the no-fault insurance for purposes of the wage loss, which Lanny mentioned earlier. So anytime you have a situation where it's an auto accident and you're on the job at the same time, I'll go back to the first thing I said. You really need to talk to an attorney to find out where you're supposed to go first, whether it be your auto insurance or the work comp insurance.
Okay.
And Craig, I've found that even if there is not workers' compensation involved, the various auto insurance policies can really be convoluted to figure out. More often than not, I find that at least one of the parties involved in an automobile accident, even if there are just two parties involved, oftentimes there's a third or fourth vehicle involved. But even if there are only two vehicles involved, I've found that one of the two parties probably doesn't own the car. They've borrowed the car. And more often than not, I find that both parties involved in a car wreck are driving someone else's car. They have insurance on their own cars, plus there is insurance on the car that they are driving. And oftentimes we see up to 4 or 5 auto insurance policies involved. There is also possible umbrella policies, liability umbrella policies that would come into effect. If you just get the police report from an automobile accident, they're going to show you, the police officer is going to write on the report the insurance card that is handed to him. So if the driver gets out their wallet and hands him an insurance card, they're going to write down the driver's personal insurance policy. If they get in the glove compartment and find the insurance card for the car, that's what the police officer will write down. So it can take some digging besides just looking at that initial police report to figure out all the potential policies involved. That's something that we haven't talked about the statute of limitations yet, but those are the types of issues that need to be addressed immediately, because as time wears on, it's harder to find the answer, and there are deadlines to assert those claims.
Well, Dan, what are the deadlines?
Well, Kentucky is a state that has different deadlines for different types of injuries, which again is why you should talk to an attorney about any time you're injured. But we're talking about auto accidents right now. Generally speaking, of course, there's exceptions to every rule, but generally speaking, when you're in an auto accident, have been injured in the auto accident, you have 2 years to pursue a claim or file a lawsuit in the case. That can be extended, that 2-year period can be extended by the payment of the no-fault benefits that we spoke about earlier. But I'm one of these people, I prefer to, I'm very cautious, and I try not to go past the 2-year statute if I can. So generally speaking, you need to file your claim within 2 years, but with the payment of no-fault benefits, that 2-year period can be extended. Just briefly, I won't go through all of them because we're going to talk about a few more. Work comp, a 2-year statute of limitation with exceptions.
Right.
Other types of injuries, malpractice injuries, slip and falls, dog bites, a lot of them have 1 year. So you can't just assume, well, this person was injured that I know and they had a 2-year statute, I must have a 2-year statute. Every case is different, which is why you really need to talk to an attorney as soon as possible so you know how much time you have. There are even some notice requirements and claims against cities and stuff that require notice to be given in a matter of a few weeks. So that's why I say really the first thing you should do after maybe getting emergency care, if you need it, is talk to a lawyer. Find out what your rights are.
One thing that I wanted to throw in is with respect to claims arising out of an automobile accident. There is one that has a 1-year statute of limitations.
Okay, the consortium claim, I assume
Yes, sir.
is the one you're referring to. Yes, if there's a husband and wife and a husband is injured in the accident, the wife can have what is called a loss of consortium claim. Strangely enough, the law is the law, but the spouse would only have a 1-year statute of limitation, as opposed to the one who is actually injured in the accident having a 2-year statute of limitation. So I'm glad you brought that up.
It's
Greg.
not logical, but it's the rule.
That is the rule, which is one of those exceptions that every rule has.
If we move beyond the issue of motor vehicle accidents, what would be some of the other most common injury-causing accidents about which either of you are contacted?
You want to take it, or?
Go ahead.
Well, probably, like I say, auto accidents are by far the number one. There's what we call slip and fall cases. Really, that applies to any type of premises or property case where you go onto someone else's property and for whatever reason you're injured, whether it be you slip on a wet floor, you trip on something that's in the floor, or something falls on you while in a store. They're called premises liability cases. Again, a lot of people call them slip and fall cases. That we get a lot of calls on those. Medical malpractice claims of people who feel they've been injured at the hands of a physician or at a hospital. We get a lot of those calls. Dog bite cases of that may seem strange, but we get a lot of calls on people being injured by another person's pets. It really runs the gauntlet.
Okay.
We
Sorry, Lanny.
cutting each other off. One other area of litigation that we see some of is known as products liability. If someone is injured by a product they are using, those can be tricky and pretty technical. The malpractice claims that Dan was talking about earlier are also very highly technical, and you do need to. I would recommend you seeing a lawyer as soon as possible if you believe that you have a claim in either one of those areas. But if you are injured because of a product, say a ladder that collapses while you are on it, you have three areas that you have to show that someone is at fault. The ladder could have been manufactured incorrectly, a rivet is out of place, a screw is out of place, and it collapsed when you stood on it. It could have been designed poorly. Or there should have been a warning on the ladder telling you see the warnings on ladders not to stand on the top step or otherwise do something. Those warnings have to be there. If a reasonable person would not have known not to do that with that product, then the manufacturer is under an obligation to put a warning on there. But again, those types of claims can be highly technical.
Yep. With going back to the one Dan mentioned next after motor vehicle accidents, the cases involving falls. Does it make a difference, for instance, whether or not I'm shopping in a retail store and sustain an injury due to falling on a foreign substance, and say I'm visiting a friend at their derby party, or I'm cutting across somebody else's backyard without their permission?
There's a couple of minor differences, but generally speaking, whether you're at a store or at someone's home, you have to prove that the property owner was at fault or negligent in some manner. I get a lot of people believing that simply because they go on to someone else's property and they're injured on someone else's property, the property owner's responsible. That's just not true. You have to prove that something was done negligently. In other words, that the property owner is at fault for some reason. Just like any other case, sometimes that can be relatively easy to prove. Sometimes that can be very difficult to prove. But no, it's just because it happens on someone else's property doesn't make them automatically responsible.
If you do sustain some sort of fall injury on someone else's property, is there any type of insurance recovery from the property owner's insurance that may pay the medical bills or part of the medical bills, regardless of whether or not the property owner is at fault? Lanny?
There can be. There is a type of coverage called med-pay coverage, medical pay coverage, that is similar to no fault. It is not required on homeowners policies or property owners policies like it is in auto policies. But if there is med-pay, it pays regardless of fault, like the auto no fault does. It is usually for a smaller amount than the $10,000 in no fault, but it can be up to a few $1,000s, which is very helpful to get those initial bills paid.
Well, Dan, what if somebody's trespassing on my in my back field and falls into a hole and hurts themselves? Is there any set of circumstances, even if they can prove I was negligent in not putting up warning signs about that hole?
Sure. A lot of people think that there are no duties owed to trespassers, and generally speaking, that may be true. But again, there's exceptions to every rule. And in certain circumstances, for example, when you know people are trespassing, I don't know if this is where you're going. Obviously, you can't set up, devices that will intentionally injure trespassers who come onto your property. I'm sure we've all heard of those cases where people have guns set up because they know someone's walking across a particular part of their property. You can't intentionally injure trespassers, even though they really have no right to be on the property. Obviously, if you know of people coming onto your property and there is potentially a danger on your property, you may very well have a duty to warn them, even though they have no right to be on your property. So even under some set of circumstances, trespassers have rights.
One of the things that a lot of people believe is if they let somebody come fish in their pond or come hunt on their land, that puts them at risk for some sort of personal liability. Does Kentucky have something called a recreational user statute that addresses that?
Well, it's been a while since I looked at that. The last time I looked at the statute, I believe there is a recreational use of where I looked at it more from the standpoint of parks. Sometimes when parks open up their lands for public usage, there are certain laws that provide certain immunities to those individuals. Now, when it comes to individual property rights, it pretty much goes without saying that if you're charging those people to come on your property and fish, you're pretty much going to be opened up to liability. If you're charging a fee for people to come on your land to hunt or fish, you better make sure it's safe when they get out there.
Right. And my understanding of the recreational user statute is that basically if you're allowing them to come on your property for recreational purposes for free.
Free of charge, okay.
Then that essentially eliminates the obligation to use reasonable care with respect to those people while they're on your property.
Right. Like the parks. When I've looked at it, it was in regard to parks, but it would be recreational use would certainly apply to the parks potentially as well.
One aspect of Kentucky law that always struck me as different from what most people believe is if we have a big snowstorm, whether you're a merchant or whether you're a city residence owner, do you have any legally enforceable obligation to go shovel the snow off your walk or salt them down?
Go ahead.
Okay. Well, no, but if you do, you better do it right.
That's right.
Generally speaking, of natural elements, ice, rain, that fall naturally and occur naturally on the ground. Generally speaking, if someone falls on those, there again exceptions to every rule, but generally speaking, those are hard cases for the injured person to prosecute. But if they've done anything without going out there trying to clear the ice, trying to dispense with the hazard, they better do it right, because it's one of those situations where a person might think that it's clear and it's really not. In other words, you're almost, when you do that, you're allowing people to, I guess, sort of drop their security, thinking it's clean when it's not. And also when it's not a natural accumulation of, a lot of times ice will build up around gutter areas where water comes out onto the concrete, and large patches of ice may pile up there as opposed to just out generally in the parking lot somewhere. Special precautions need to be taken in those areas. But generally speaking, natural element cases are tough, but that's not to say property owners, they don't have to do anything, because there's a lot of exceptions to that rule as well.
And I think we're going to see, they haven't started coming in my office yet, but I'm expecting them to see them any day now. And that is claims arising from the ice storm and the hangers that we see. I've seen most people in town have cut back the hangers, by the limbs that are just hanging on by a thread and kind of dangling there. Every time a stiff wind blows, I get nervous that one of those are going to come down. I don't know the answer here, sitting here today, which we all three could probably debate for the rest of the hour on what the liability would be if that tree came down and injured someone. I would have some concerns immediately, though, if on my property there were trees that were hanging and I knew that they were hanging. and it injured someone especially on a public roadway, I would have a great deal of concern.
Or if, you know, the tree that the trunk is clearly on your property and the hanger is right over the sidewalk that is used by the public every day and you
Right.
know it. You put those circumstances together and then reasonable people might think the homeowner had some duty.
Yeah, I think the more specific the hazard of the tree limb hanging, something like that, I think that's going to put a greater duty on the homeowner to fix it, as opposed to trying to get rid of an entire parking lot of snow or something like that, if you're talking about a specific hazard.
One of the things that I have been asked before, and it always sort of surprised me when I looked at the law in Kentucky on this, is if someone is renting a home or renting an apartment to another person, does the landlord have a duty to maintain the apartment or the house in a safe condition? Either of y'all want?
Oh, go ahead. I'm
The
sorry, Lanny.
times I've dealt with that, I've found that as to a third party, that the tenant is responsible for the safety to the third party. Unless now there can be, and this is another reason to consult a lawyer if you get hurt on somebody's property, because the duties can be defined by the lease, and sometimes the landlord maintains some duties, some responsibilities, because they are supposed to maintain the outer areas and some of that nature. But my understanding is, absent a lease term, as to an injury to a third party, then it's the tenant's responsibility, not the landlord's responsibility. But there's exceptions to every rule.
Yep. One of those that's fairly common that you might touch on, Dan, is the common areas or common approaches.
Right. If you look at things from the standpoint of a specific house, there's really not common areas. But if you look at an apartment complex, where, for example, the pool area, where everyone has access, or lobbies, common areas, those will usually stay within the responsibility of the landlord, because obviously when you have multiple tenants, renters, it's not the duty of any one to take care of the common area for all, so that will usually fall back on the landlord.
Okay. And just make sure we're clear on this. What is the time limit, if any, for filing a claim if someone's been injured and they think it is due to some negligence on behalf of the company or the person who owns the premises?
Okay, again, on the premises liability cases, the slip and fall cases, generally it's 1 year, but against certain defendants, you might have to give notice of your intention to pursue a lawsuit in a matter of weeks after the incident happens. So again, contact the attorney, because even though you might have 1 year to file a claim, you might have to give notice of your intent to file a claim well before the 1 year statute.
There are some limited circumstances in which the statute can be extended if you could not find out who the person responsible for the injury was. The extension is more likely in cases where you were unaware you were injured, such as in a medical malpractice situation or in a chemical exposure situation where you did not realize you were even sick until years later. That 1 year statute of limitations can be extended. It's possible that it can be extended if you did not know the identity of the person who caused the problem. But the law in Kentucky is that if you could have found the person through the exercise of reasonable diligence, then your statute has run. You have an obligation from the day that you are injured to start trying to find out who was responsible for that injury.
And if I could just add that, we're talking about statutes of limitations, time deadlines. As we say, there's general rules. Even if more than 1 year has passed, it's still a very good idea to talk to an attorney, because there are exceptions to these 1 year statutes of limitation and 2 years, and one of those exceptions may apply to you. So even if you think you have waited too long, check with an attorney and find out.
Okay. One of the other areas of law that we've touched on is under the heading of medical malpractice. And Dan, does your firm get asked about medical negligence cases often? And if so, how many of those do you wind up thinking are a good case?
Well, yes, we get asked about medical malpractice claims a lot, and although we'll get to it in a second, it's sort of like river claims. We get a lot of calls on river claims. Why? For good reasons. Paducah is sort of a hub here for medical treatment and the river industry, and I'll answer your question on the medical treatment. Obviously have 2 hospitals, a lot of doctors. We get a lot of calls regarding medical malpractice claims, whether it be against a particular physician or a hospital or nursing home. I would certainly include that in a medical malpractice. One of the issues with a medical malpractice claim is when deciding whether or not there's a case or whether or not to take a case. A lot of times there's cases there. There's no question something was done wrong to the person and they've been injured by it. A lot of times the issue becomes whether or not the injury is going to, and I hate to say it this way, have more value than what it's going to cost to prosecute the case, because medical malpractice claims are expensive to prosecute. And so no, not every case that we get a call on do we take when it comes to medical malpractice because of the cost of litigating that type of claim.
I have heard from other attorneys who have handled medical negligence claims that they will accept maybe 1 in 30 to 1 in 50 of the inquiries where they interview the person.
That is correct. There's a lot of calls. I guess you would call it a high ratio from the take cases to the number of cases you hear to the ones you take. It could be the ratio you just gave. That is absolutely correct.
Okay. In terms of the costs of processing a claim, Lanny, I think you talked about products liability. Is there some comparable hurdle or barrier that is inherent in the nature of the claim if you're processing a claim that someone's product was defective and that's the reason that you sustained an injury?
Absolutely. In the same way that medical malpractice can be expensive because you have to hire a doctor to give your side of the story, you have to do the same thing in a products liability, probably have to do the same thing in a products liability case. And you're also very possibly dealing with very deep pocket defendants on the other side who will spend what they need to spend to defend their case. And if people joke about that lawyers can be expensive, but until you hire an expert to help you with a products liability case or a medical malpractice case, you don't understand hourly rates. It can be very expensive to both prosecute and defend both of those types of cases.
And with respect to malpractice or products liability, are you having to buy the expert's time usually by the day if it goes to trial?
Yes, by the hour, by the day. The hourly rates are very high, and usually a whole day's worth for an hour's work. It can be a very expensive process.
And a lot of times the experts are not local. They're from out of town, and of course travel expenses on top of the time. It can be very expensive.
And who winds up paying that in the event the case is tried and the injured person loses with the jury?
Well, each party is responsible for their own costs and expenses, even if they win. Now, there are certain expenses that the other side may have to pay. They're called taxable court costs. But generally speaking, taxable court costs are usually a very small percentage of the true actual costs of prosecuting a case. And every case is different, but you might have $20,000 of litigation expenses in the case, but only be able to recoup maybe 10% of those from the other side, even if you win the case. So generally speaking, the expenses that you incur in prosecuting your case are your expenses, win or lose.
And with respect to products liability claims, once again, what is the time limit that within which such a claim must be brought?
For a personal injury, it's 1 year.
Okay.
And again, we talked about some possible exceptions if you did not realize. We see this some in chemical exposure cases where people did not realize they were injured until years later when the chemical exposure caused cancer. But those are very limited exceptions, and for the most part, the statute of limitations is 1 year.
Okay. Is there some advice to anyone who consults you with respect to a potential product failure with respect to the product itself? I mean,
Well, we've had cases where people have come into the office with a potential products claim. They threw away the product. They decided that they got so mad they threw it away, then they decided to come see us. If it is a product like a ladder or a home, something for home use, if you don't have the product that caused the injury, then you're probably going to have a hard time proving your case.
okay. So when they threw away the ladder, they threw away the case.
They probably threw away their case.
Okay. Okay. One of the things is the dogwoods.
I say probably. There's exceptions to that.
Sure.
Just because you've thrown something away doesn't mean you shouldn't go seek legal advice. I don't want to say anything is an absolute here today.
That makes good sense. Dan, we live in an area that's surrounded by water. We've got the 4 major rivers. We've got the 2 big impoundment lakes. And unfortunately, people get hurt, people get killed in connection with boating on the waterways or recreation around the waterways or work around the waterways. Are there any special rules that apply or insurance considerations when we're talking about injuries on the water?
Well, if you're looking at protecting yourself, meaning that you own the pleasure craft, maybe many people know this already, but just do not assume that your homeowner's coverage is going to cover you if you are out on a boat and, however it may happen, you injure someone else who's riding with you. You really need to make sure that your homeowner's policies provide coverage for that particular boat. I know many policies say that if a boat is over a certain length, you have to have a special type of endorsement or actually a separate policy for that particular boat. So the first thing to do is check with your insurance agent, say, I have this boat, insure it, or if he says, no, it's covered by your homeowners, I'd like to get that in writing, please. So one, just make sure you're covered with your insurance agent, that the boat's covered. Of course, then if you are the one injured, boy, that can run the gauntlet to the people who work on the river industry, whether it be a person working on a boat, a deckhand. That might be a Jones Act case. A person working on land who repairs or maintains barges and other boats, that could be a longshoreman's case. A person who works in the office at a particular riverboat's business could be a work comp case. So the same business, the river business, you might have a Jones Act case, you might have a longshoreman's case, or you might have just a straight work comp case, each one having a different statute of limitation or time deadline for filing. So it's a very ominous area of the law.
Even recreational injuries on a body of water can have a different area of law applied. General maritime law has some differences with Kentucky law. The comparative fault we talked about earlier can be different. The contribution among the people who may have caused the accident can be different. So you could speak for a long time about the differences between the Kentucky law versus the maritime law, which is nationwide.
Right, and if you're talking about injuries as the result of something the government did wrong, navigable waterways, or federal waterways, you might have a Federal Tort Claims Act, which is a whole nother area of the law. So anytime someone is injured on the water or near the water, it could be one of any number of claims that you could bring.
And you mentioned Longshore, Jones Act.
Federal Tort Claims.
Federal Tort Claims Act and a civil damage suit.
Right.
Is it accurate that all of those have a different time limit to bring them, and every one of them's before a different forum, and every one of them's got a different set of rules?
That's exactly right. A couple of those claims have 1-year statutes of limitation. Work comp has 2-year statutes of limitations. Jones Act, I believe, has a 3-year statute of limitation. But even if you think you have a Jones Act case, you better check with a lawyer, because it may not be a Jones Act case. It may be a longshoreman's case, and you really only have a 1-year statute of limitation. So they're very, very tough to navigate, as they say.
That's a good one. Let's see, I'm trying to think of what we haven't covered. We haven't talked about people who own dogs and the potential liability of people who own dogs or horses or cows or that sort of thing. Is there some risk associated to owning dogs, cats, horses, what have you? Lanny?
There is some risk. If you have a creature that is inherently dangerous, it can even rise to the level of what we call strict liability. If you have a pit bull that's trained to fight, and the pit bull escapes and injures someone, then they may not. The other side may not even have to show that you were negligent in letting the animal out. Just the fact that you owned an animal that was inherently dangerous. If you owned a tiger or something of that nature. I'll let Dan address the general negligence principles of a house pet.
Right, and I will add just a lot of people used to say, you got the one free bite rule, that a dog can bite one person and it's okay, but if they bite that's not true. Even if you bite, a dog bites a person once, their owner can be held responsible for the actions of their animal. And it really may not matter how safe they're trying to be, even if they never knew that animal to have ever bitten someone before. Many times, as Lanny mentioned, the person can be held strictly liable, which is a way of saying, if it happens, you're liable. It doesn't matter what type of precautions you took.
Let me ask you what somebody can do to protect themselves in that circumstance. Like, I know you told us that if you own a boat, make sure that your homeowners will cover up to 16 feet, and if you've got one that's 16 feet 3 inches, you may need another
Right.
policy. What sort of policy would cover the person who owned a dog who had bitten one person already?
Well, again, it goes back to homeowners policies. Generally speaking, the ones that I have seen do cover people if their animal or pet would injure someone else. Most homeowners policies, again, check with your agent. If it's a farm industry where it's horses and cows, you'll probably have to purchase a separate type of policy for that, because it's not a pet. They're sometimes called rancher policies or farm policies, and those have to be specifically purposed for livestock purposes. And you better make sure your fences are safe and secure so they can't get out.
Craig, I would recommend that anybody talk to their insurance agent about their daily activities, because a lot of things people assume are covered, and we see this quite a bit, are not covered. And there's a lot of exclusions in insurance policies. So if you have a babysitter who works for you that drives your vehicle, if you own a golf cart that you just play around in your yard with, there's just a lot of small things you would think would be covered under your homeowners or your auto owners that are not, and that you really should talk to your agent about your daily activities and make sure everything you're doing would be covered.
And just because you've got full coverage doesn't mean you've got enough coverage.
Exactly.
And I think we're about, we've covered up the time that we were allotted, and we want to thank our listeners for joining us with the People's Law School segment on personal injury law.
Good.